The Supreme Court of the United States just made a move that has sent shockwaves through the gun rights community. They have fast-tracked a major case involving assault weapon bans, and this means they are going to hear arguments and make a decision much sooner than anyone expected. This is not normal. When the Supreme Court fast-tracks a case, it means they believe it is urgent and important enough to skip the normal waiting periods. That should tell you something about how serious this situation is. If you own any type of semi-automatic firearm, any rifle that might be classified as an assault weapon, or even a standard hunting rifle that shares features with banned weapons, you need to pay close attention to everything I'm about to explain. The government is counting on you not knowing what is happening. They count on you being confused by legal language and court procedures. But once you understand what is going on, you can protect yourself and your rights. That is what this channel is here for. I am going to walk you through exactly what the Supreme Court did, why they did it, what happens next, and most importantly, what you need to do right now to protect yourself. Let me start by explaining what the Supreme Court actually did. The Supreme Court agreed to hear a case that challenges state-level assault weapon bans. They granted something called certiorari, which is a fancy legal term that means they agreed to take the case and make a final decision. Normally, the Supreme Court takes years to hear cases. They have a huge backlog, and they pick which cases they want to hear based on their significance. But in this situation, they moved much faster than usual. They fast-tracked it, which means they are going to hear arguments and issue a decision on a much shorter timeline. This matters because the states that have assault weapon bans are enforcing them right now. People are being charged with felonies, having their weapons seized, and facing prison time because of these laws. When the Supreme Court fast-tracks a case, it means they believe the issue is so important and so urgent that waiting the normal amount of time would cause serious harm. They want to resolve this as quickly as possible, and that urgency should tell you something about how significant this ruling could be. The case involves several states that have passed laws banning what they call assault weapons. These bans typically target semi-automatic rifles like the AR-15, the AK-47, and other firearms that share certain features. The features that trigger these bans usually include things like a pistol grip, an adjustable stock, a barrel shroud, and the ability to accept a magazine that holds more than 10 rounds. These are called cosmetic and functional features, and they are the basis for classifying a firearm as an assault weapon under these laws. Now, before I go further, I need to explain something important. The states that have these bans are arguing that they have the authority to regulate firearms for public safety. They point to the fact that the Second Amendment says well-regulated militia, and they interpret that to mean that reasonable regulations are allowed. They also point to historical precedent showing that certain types of weapons have been regulated throughout American history. The other side, the gun rights advocates, are arguing that the Second Amendment protects an individual's right to own firearms for self-defense, and that semi-automatic rifles are commonly owned by millions of Americans for legitimate purposes like target shooting, hunting, and personal protection. The states fighting these bans are making several specific arguments. First, they argue that the Second Amendment protects weapons that are commonly used for lawful purposes. They point to millions of Americans who own semi-automatic rifles for target shooting, hunting, and self-defense. They argue that these weapons are in common use, which means they cannot be banned under the Supreme Court's previous rulings. Second, they argue that the features used to define assault weapons are arbitrary and do not actually make the weapons more dangerous. A semi-automatic rifle with a pistol grip fires no differently than one without a pistol grip. The cosmetic features that trigger these bans do not change the fundamental function of the weapon. Third, they argue that these bans effectively strip away a significant portion of American citizens' Second Amendment rights without a compelling justification. The Supreme Court has already ruled on this issue in some important cases. The most significant is the 2008 case called District of Columbia versus Heller. In that case, the Supreme Court ruled that the Second Amendment protects an individual's right to own firearms for traditionally lawful purposes like self-defense within the home. That ruling was 5-4, which means it was a very close decision. Then in 2010, in a case called McDonald versus Chicago, the Supreme Court ruled that the Second Amendment applies to state and local governments, not just the federal government. These cases established that the Second Amendment protects an individual's right to own firearms, but they also left some questions open about how far that right extends and what types of regulations are allowed. Now, the current case is different because it deals specifically with semi-automatic rifles and the features-based approach to defining assault weapons. The states are arguing that these weapons are not protected under the Second Amendment because they are unusually dangerous or because they are not traditionally used for self-defense. The gun rights advocates are arguing that millions of Americans lawfully own these weapons and use them for legitimate purposes, which means they are commonly used for lawful purposes and therefore protected. Here is what happens next in this process. The Supreme Court will hear arguments from both sides, likely within the next few months. They will then issue a written decision, probably sometime in the spring or early summer. That decision will be the final word on this issue, at least for now. But there is an important thing to understand here. While the Supreme Court is considering this case, the existing state bans are still in effect. The court has not ruled yet, so they have not struck down these laws. That means if you live in a state with an assault weapon ban, that ban is still being enforced right now. People are still being charged, weapons are still being seized, and rights are still being violated while the case makes its way through the system. This is why I am telling you about this now. You cannot wait until the Supreme Court makes a decision to start preparing. If you own any firearm that might fall under one of these bans, you need to understand exactly what the laws say, what your options are, and what steps you need to take right now. The government is not going to wait for the Supreme Court to protect you. You need to protect yourself. Let me walk you through 5 critical steps that every gun owner needs to take right now. I am going to give you specific actions you can take today, this week, and this month to protect yourself and your rights. Step 1 is to know exactly what your state law says. This is the most important thing you can do. I cannot stress this enough. Every state has different laws, and what is legal in one state might be a felony in another state. You need to find out exactly what the assault weapon ban rules are in your state. I know this sounds simple, but you would be amazed at how many people do not know what the specific laws are in their own state. They think they understand the general rules, but they do not know the specific details that could get them into trouble. Go to your state government's website, find the penal code section that deals with firearms, and read the actual law. Do not rely on what other people tell you. Do not rely on what you heard in a YouTube comment. Read the actual law yourself. Or better yet, have a lawyer who specializes in gun rights read it and explain it to you. Step 2 is to document everything you own. If you own any firearms that might be affected by these bans, you need to keep detailed records. Take photographs of every firearm from multiple angles. Keep records of when you purchased each firearm, where you purchased it, and any serial numbers or identifying information. Save all your receipts and transfer documents. This documentation could be critical if you ever need to prove when you acquired a firearm or that you owned it before a certain date. Some of these laws have retroactive provisions or grace periods for weapons purchased before the law took effect. Having good documentation could be the difference between keeping your property and losing it. Step 3 is to know your legal options. If your state has an assault weapon ban, find out what legal challenges are available. Are there organizations fighting these bans in court? Are there registered FFL dealers who can help you transfer property to a friend or family member in a state where it would be legal? Are there storage options that could allow you to temporarily remove the weapon from the state while the legal challenges play out? These are complicated questions with complicated answers, and the answers are different for everyone. But you need to start asking these questions now, not after you have already run into legal trouble. Step 4 is to understand the consequences of not complying. This is not something to take lightly. If you are caught with a banned firearm in a state that has an assault weapon ban, you could face felony charges. You could lose your right to own firearms entirely. You could go to prison for years. These are not minor consequences. These are life-altering consequences that can affect your job, your family, your reputation, and your freedom. I know some people think they will just take their chances, but I'm telling you right now, the risk is not worth it. The legal system is not on your side in these states. The prosecutors are aggressive, and the judges are often unsympathetic to Second Amendment arguments. Protect yourself by understanding the stakes and making smart decisions. Step 5 is to stay informed about changes. Laws change, court rulings come out, and what is true today might not be true tomorrow. You need to stay on top of developments in your state and at the federal level. Subscribe to reliable sources of information. Join organizations that are fighting for your rights. Talk to lawyers who specialize in this area. Do not assume that because something was legal last year, it is still legal now. The legal landscape is constantly changing, and you need to keep up with those changes to protect yourself and your family. Now, let me explain some of the legal arguments on both sides so you understand what is actually at stake in this Supreme Court case. I want you to understand the constitutional issues, not just the surface level news about what happened. Understanding the legal principles will help you understand what the Supreme Court is likely to do and why. The states that pass these assault weapon bans are making several arguments. First, they argue that the Second Amendment was written in a different time, when the most advanced weapons available were single-shot muskets. They argue that the founders could not have anticipated modern semi-automatic rifles, and therefore the Constitution does not specifically protect access to these weapons. They also point to the well-regulated militia language and argue that the amendment was intended to allow states to maintain militias, not to protect individual ownership of any weapon a person might want to own. Second, the states argue that there is a historical tradition of regulating dangerous weapons. They point to historical examples like the banning of sawed-off shotguns in the early 20th century, laws against carrying concealed weapons, and other regulations that limited access to certain types of firearms. They argue that reasonable regulations have always been part of the Second Amendment framework, and that assault weapon bans are simply the modern equivalent of these historical regulations. Third, they argue that the government has a compelling interest in protecting public safety. Mass shootings with assault weapons have resulted in hundreds of deaths. The states argue that they have an obligation to protect their citizens from these tragedies, and that allowing these weapons to remain in circulation poses an unacceptable risk to public safety. They point to the deaths from mass shootings as evidence of the harm these weapons can cause and argue that the government has a responsibility to act. The gun rights advocates are making equally strong arguments on the other side. They argue that the text of the Second Amendment is clear. It says, "The right of the people to keep and bear arms shall not be infringed." They argue that arms means all weapons, and that the government cannot pick and choose which weapons are protected based on what it decides are acceptable. They point to the prefatory clause about militias as context for understanding the purpose of the amendment, but they argue that the operative clause protects an individual right that exists independent of militia service. They also argue that the well-regulated militia language supports their position. They point out that a well-regulated militia requires armed citizens who are trained and equipped. If the government could ban any weapons it considers too dangerous, then no militia could ever be properly regulated. The founders wanted citizens to be armed so they could defend themselves and their communities, and that requires access to effective weapons. The gun rights advocates also challenge the factual basis for these bans. They point out that the features used to define assault weapons are arbitrary and do not make the weapons more deadly. A standard hunting rifle with a wooden stock fires the same ammunition with the same rate of fire as an assault weapon that has been banned. The cosmetic features that trigger these bans do not change the fundamental function of the weapon. They argue that the states are basing these laws on emotional reactions to the appearance of certain firearms rather than any meaningful technical distinctions. Finally, they argue that these bans effectively destroy the Second Amendment rights of millions of Americans. If the government can ban one category of commonly owned firearms, it can ban other categories. There is no logical stopping point if these bans are allowed to stand. Eventually, the government could argue that handguns are too dangerous, or that pump-action shotguns are too dangerous, or that any firearm that can be used in a crime is too dangerous. The gun rights advocates argue that the only way to protect the Second Amendment is to reject these bans entirely and apply the Constitution as written. The Supreme Court is going to have to decide between these two positions, and the decision they make will affect every gun owner in the country. If they side with the states, these bans will likely be allowed to stand, and other states will feel empowered to pass similar laws. If they side with the gun rights advocates, these bans will be struck down, and the states will have to find other ways to address their public safety concerns. Here is what you need to understand about the timeline. The Supreme Court fast-tracked this case, which means they want to make a decision quickly. The earliest we might see a decision is in the spring, but it could take longer depending on how the arguments go and how complex the legal issues are. In the meantime, the existing bans are still in effect. If you live in one of the states with a ban, you are subject to that law right now, today, regardless of what the Supreme Court eventually decides. Some people are asking whether they should sell their firearms before a potential ban takes effect, whether they should move to another state, whether they should store their weapons with someone in another state, or whether they should take other steps to protect themselves. These are all personal decisions that depend on your specific circumstances, and I cannot tell you what the right choice is for your situation. What I can tell you is that you need to think carefully about these decisions and get advice from a qualified lawyer who knows your specific situation. There are some potential exceptions and loopholes in these laws that might apply to some people. Some states have grandfather clauses that allow people who already owned banned weapons to keep them. Some states have registration requirements that, if followed, allow you to keep weapons that would otherwise be banned. Some states have exemptions for certain professions or certain situations, but these exceptions are complex and vary from state to state. You need to find out what exceptions apply in your state and whether you qualify for any of them. Let me give you some examples of how these exceptions work in practice. In some states, if you owned a banned weapon before a certain date, you can keep it as long as you register it with the state and follow certain storage and transport rules. The registration process usually requires you to provide detailed information about the weapon, including the serial number, your personal information, and sometimes photographs. You typically have to pay a fee for registration, and there is usually a deadline for registering. If you miss the deadline, you lose the exception and the weapon becomes illegal. Some states also have exemptions for law enforcement officers, retired law enforcement officers, and certain security professionals. If you are a current or retired law enforcement officer, you might be able to legally possess a banned weapon even in a state with an assault weapon ban. But these exemptions usually come with strict conditions, and you need to make sure you understand exactly what is required of you. There are also sometimes exceptions for museums, armorers, and certain commercial enterprises. If you work in the firearms industry, or if you have a legitimate business reason to possess these weapons, you might qualify for an exemption. But again, these are complex legal questions, and you need to get advice from a qualified lawyer before assuming you qualify for any exemption. What happens if you do not take these steps and you get caught with a banned weapon? Let me be very clear about this because I want you to understand the stakes. In most states with assault weapon bans, possessing a banned weapon is a felony. That means you could be charged with a crime that carries a prison sentence of 1 year or more. You could lose your right to vote, your right to own firearms, and your right to hold certain jobs. You could be ordered to pay fines and restitution. You could have your weapons seized and destroyed. You could face federal charges on top of state charges. These consequences are real and they are serious. I know some people think they will never get caught. They think they can hide their weapons and no one will ever know. But here is what you need to understand. If you get caught, even once, your life changes forever. The legal system will not show you mercy because you are a good person or because you did not mean any harm. The laws are written to punish possession of these weapons regardless of your intent. You could be the most careful, law-abiding gun owner in the country, and if you are caught with a banned weapon in a state with an assault weapon ban, you will face serious consequences. This is why knowing your rights is so important. This is why understanding the laws in your state is so critical. This is why taking steps to protect yourself before you get into trouble is the smart move. You cannot go back in time once you have been charged. But you can prepare yourself now so that you do not end up in that situation. Let me also address something that a lot of people are asking about. Some people are wondering whether they should challenge these laws themselves, whether they should refuse to comply, whether they should engage in civil disobedience to make a point. I understand the temptation. You believe in your rights, you believe these laws are unconstitutional, and you want to fight back. But let me explain why that approach is dangerous and likely to backfire. Civil disobedience might work when the law you are challenging is something like a permit requirement or a storage rule. But when you are facing potential felony charges for possessing a banned weapon, civil disobedience is not a smart strategy. If you are charged and convicted, you lose your rights anyway. You become a felon, which means you can never own a firearm again. You go to prison. You lose your job, your family, and your freedom, all because you tried to make a point. The better approach is to work within the system. Support the organizations that are fighting these bans in court. Make political contributions to candidates who support your rights. Vote for representatives who will protect the Second Amendment. Write letters to your elected officials. Use the legal system to challenge these laws rather than trying to ignore them. These approaches take longer and they are less dramatic, but they are much more likely to be effective in the long run. The Supreme Court case that is being fast-tracked right now is exactly the kind of legal challenge that can change the landscape for everyone. The organizations bringing these cases are doing the hard work of building legal arguments, finding plaintiffs with standing to sue, and navigating the court system. They are spending years and millions of dollars fighting these bans through legal channels. That is the way to create lasting change, not individual acts of civil disobedience that end up sending good people to prison. I want to wrap up by reinforcing the most important points from this video. First, the Supreme Court has fast-tracked this case, which means they think it is urgent and important. Second, the existing bans are still in effect while the case is being decided. Third, you need to know exactly what the law says in your state. Fourth, document everything you own. Fifth, understand your legal options and the potential consequences of noncompliance. Sixth, stay informed about developments as they happen. The government hopes you never learn about these rights. They hope you do not understand what is at stake. They hope you will assume that because something is a law, it must be constitutional. But that is exactly why I am here. This channel exists to give you the knowledge you need to protect yourself, your family, and your rights. Do not let this information go to waste. If you know someone who owns firearms, someone who might be affected by these bans, someone who is not paying attention to these legal developments, share this video with them, send them the link, tell them to watch it and share it with others. The more people who understand what is happening, the better. That is how we change things. One person at a time, one share at a time, one video at a time. Knowledge is your best protection. If you have not subscribed to this channel yet, please do that now and hit the bell so you get notifications when new videos come out. Court decisions are happening every week that affect your rights, your money, and your freedom. When they happen, I break them down so you understand exactly what they mean and what you need to do. That is what this channel is here for. Do not miss out on the information that could protect you and your family. Remember the one thing from this video. Know your state's laws. Know what the ban says in your state. Know whether it applies to you. Know what the deadline is for any registration or compliance requirements. Know what the consequences are if you do not comply. That one thing, knowing your state laws, could save you from felony charges, from losing your rights, from losing your freedom. Everything else in this video was just explanation. But knowing your specific state laws is the action step you need to take right now. Go check your state's laws today. Read the actual statute, find out what the deadlines are, find out what the penalties are. And if you have questions, talk to a lawyer who specializes in this area. Do not wait until you are facing charges to start learning. By then, it is too late. Thank you for watching. Share this video with everyone who needs to hear it. And remember, knowledge is your best protection. The government counts on you not knowing your rights. This channel changes that.